If you are dreaming about studying in the United States, getting that student visa feels like the final door between you and your future. You get your admission letter, you pay your SEVIS fee, you schedule your interview, you prepare your documents, and then in just a few minutes at the U.S. Embassy or consulate, a consular officer says one word that changes everything: refused. No long explanation. No detailed feedback. Just a section number like 214B or 221G. And suddenly your American dream feels like it is collapsing. But here is the truth: most student visa rejections are not random, and they are not personal. They are legal decisions based on U.S. immigration law. If you understand the legal reasons behind student visa rejections, you can dramatically increase your chances of approval the next time. In this video, we are going deep into the real legal reasons why F1 student visas are denied, how U.S. law works behind the scenes, what officers are actually evaluating during those short interviews, and what you can do to avoid becoming another rejection statistic. First, you must understand one powerful legal principle that controls almost every student visa interview, Section 214B of the Immigration and Nationality Act. Under U.S. law, every applicant for a non-immigrant visa, including an F1 student visa, is presumed to be an immigrant. That means the law automatically assumes you intend to permanently stay in the United States unless you prove otherwise. This is not about suspicion. It is not about discrimination. It is the legal starting point. The burden of proof is entirely on you. During your interview, you must convince the officer that you have strong ties to your home country and that you intend to return after completing your studies. If you fail to overcome this presumption, your visa will be refused under 214B. This is by far the most common reason for student visa denial. Now let us break down what strong ties legally means. Strong ties are connections that bind you to your home country. These can include family relationships, property ownership, a job offer after graduation, business interests, financial assets, or long-term career plans rooted in your country. Weak ties mean the opposite. If you are young, single, unemployed, with no property and no clear career path back home, the officer may conclude that you have stronger incentives to remain in the U.S. than to return. Even if you personally plan to return, the officer must make a legal determination based on probability. They are not reading your heart. They are evaluating risk. And because immigration fraud and overstays are real issues, officers are trained to look for indicators that suggest possible immigrant intent. Another major legal reason for rejection is financial insufficiency. Under U.S. law, F1 students must prove they have sufficient funds to cover tuition, living expenses, and other costs for at least the first year of study, and credible funding for the remaining years. This requirement is not optional. It is written into the regulations governing student visas. If your bank statements are inconsistent, if large unexplained deposits suddenly appear before your interview, or if your sponsor's income does not logically support the amount required, the officer may doubt the authenticity or sustainability of your financial support. Even if your documents technically show enough money, the officer may question whether the funds are genuinely available for your education or just temporarily arranged to pass the interview. Financial credibility is as important as the numbers themselves. A third legal reason involves academic credibility and program relevance. U.S. immigration law requires that your primary purpose in traveling to the United States is to pursue a full course of study at an approved institution. If your academic history does not align with your chosen program, or if the program seems illogical given your background, the officer may question whether you are a genuine student. For example, if you already hold a master's degree and apply for a second similar degree without a clear academic or career justification, that can raise red flags. If you have very low academic scores but suddenly enroll in a highly competitive institution without a strong explanation, that may also create doubt. The officer is evaluating whether your education plan makes sense. They are trained to detect cases where education may be used as a pretext for entry rather than the true purpose. English proficiency can also become an indirect legal issue. While there is no law that says you must speak perfect English during your interview, if you are applying for a program taught entirely in English and you struggle to answer basic questions, the officer may doubt your ability to succeed academically. That doubt can translate into concerns about your true intentions. If you cannot clearly explain your chosen field of study, your university, or your future plans, it may appear that you are not genuinely invested in the academic opportunity. Another serious legal ground for refusal is misrepresentation or fraud. Under Section 212(a)(6)(c)(i) of the Immigration and Nationality Act, any applicant who willfully misrepresents a material fact to obtain a visa is permanently inadmissible to the United States. This is not a simple denial. It can become a lifetime ban. If you provide fake documents, false bank statements, fabricated employment letters, or incorrect information about your academic history, and the officer discovers it, the consequences are severe. Even small lies can have massive consequences. For example, hiding a previous visa refusal, concealing a relative living illegally in the United States, or lying about your work history can trigger a finding of misrepresentation. Once that finding is made, future visa approvals become extremely difficult. Previous immigration violations are another major legal factor. If you previously overstayed a U.S. visa, worked without authorization, violated the terms of a prior F-1 status, or were unlawfully present in the United States, you may face automatic bars under Sections 212(a)(9)(b) or 212(a)(9)(c). Depending on the length of unlawful presence, you could be barred for 3 years, 10 years, or even permanently. Even if you are not subject to a formal bar, a history of non-compliance can heavily influence the officer's discretion. Consular officers have access to extensive databases, including prior visa applications, travel history, and immigration records. They can see more than you think. Another legal issue arises under Section 221(g), which is technically not a final refusal but a temporary denial pending additional administrative processing or missing documents. Many students panic when they receive 221(g), but it often means the officer needs more information, security clearance, or documentation. However, if you fail to provide the requested documents or if administrative processing uncovers problems, the case can eventually convert into a final refusal. Security-related grounds are also embedded in U.S. immigration law. If your field of study falls within sensitive technological areas such as advanced engineering, nuclear sciences, artificial intelligence with military applications, or biotechnology with dual-use concerns, your application may trigger additional security review. This does not mean you did anything wrong. It means your case requires extra scrutiny under U.S. national security protocols. Administrative processing in such cases can take weeks or months. Sometimes, applications are refused if security concerns cannot be resolved. Another overlooked legal reason for rejection is inconsistent information between your DS-160 form and your interview answers. The DS-160 is a sworn application. When you submit it, you certify under penalty of perjury that the information is true and during the interview you provide answers that contradict what you wrote. Even unintentionally, the officer may question your credibility. Credibility is central to every visa decision. Once credibility is damaged, it becomes very difficult to recover during that short interview window. Now let us talk about the interview itself. Many applicants believe that if they bring thick folders full of documents, they will automatically be approved. But U.S. student visa interviews are primarily oral assessments. Officers are trained to make decisions quickly based on your answers, confidence, consistency, and overall profile. The interview often lasts only 2 to 5 minutes. Within that short time, the officer is legally determining whether you have overcome the presumption of immigrant intent, whether you are financially capable, whether you are academically